For admission, item number 1.
May it please, Your Lordship.
Yes. Yes.
Your Lordship, may kindly peruse page 32 for a moment, Your Lordship, the FIR. Referring for quashing of the FIR. Your Lordship, may kindly peruse. May I read the FIR, Your Lordship? With reference to the government letter number so-and-so, dated 1/2/2023, on the subject cited above, I am state that the under-mentioned 4 persons mentioned as serial number 3 are reported to be indulging in printing, circulating of fake lotteries in the state of West Bengal, tarnishing the image of the state. Your Lordship may kindly note that part. The government of Nagaland is organizing and conducting lotteries as per the Lotteries Regulation Act 1998 and Lotteries Regulation Rules 2010, as well as the rules of the Nagaland government and instructions issued by the Ministry of Home Affairs from time to time. The lotteries conducted by the state of Nagaland are in strict compliance with the provisions of the Act and rules which are marked in 5 states where West Bengal is one of the biggest markets. To conduct smooth marketing of Nagaland state lottery tickets in the state of West Bengal, Government of Nagaland has appointed distributors. Internally, the distributors have appointed sub-distributors, and the sub-distributors have appointed area distributors, and the distributors thereafter have appointed stockists, sub-stockists, retailers, etc. Recently, several complaints have been received from the Nodal Officer, Directorate of Nagaland State Lotteries, CAM Kolkata, and area distributor, agent stockists, sub-stockists, etc., that some persons are indulging in circulation and selling of illegal fake paper lottery tickets which flourish in various parts of West Bengal, resembling the name logo of the Nagaland State Lotteries. Now, you also may kindly note that part, the logo of the Nagaland State Lotteries. From the complaints received by this office from the various stated stockists, sub-stockists in the state of West Bengal, we have come across some common names who are involved in the printing and circulating of fake lotteries in the state of West Bengal. The names are there, these are the accused persons. Detailed list of persons and activities involved in also annexed herewith for your ready reference. These people are also trying to malign the reputation of the Nagaland State Lotteries by duplicating and using the name and logo of the state Nagaland State Lotteries in the fake and fabricated lottery tickets. Pawan Junjunwala is also involved in printing and circulating fake lottery tickets in the state of Jharkhand and Bihar, and various cases are registered in the regard in this name in different police stations. Atul Bokria also regularly files RTI applications to the department and tries to get the confirmation documents from the department, and has also filed a complaint before the enforcement director to malign the image of the Nagaland State Lotteries, and he has attached the agreement copies between the government of Nagaland and the distributor, which is confidential and is not even shared to Atul Bokria even after his repeated RTI applications. Further, in the same complaint, the enforcement director, the said Atul Bokria, was attached a confidential letter dated 23/9/2000 which was issued by the MHA to Nagaland government, which has never been disclosed in public. He is maligning the image and reputation of the Nagaland State Lotteries and has procured the documents by illegal means and is purely sharing the same in an open market. The wrongfulness of these persons are also published in newspaper and news portals, which are also enclosed herewith for your kind perusal. An FIR is already registered against him in the state of West Bengal. This may be noted here. Further, the accused above named persons are also engaged in producing, manufacturing fake prize-winning lottery tickets, which, after telling the same from the result published by the Nagaland State Lotteries. Your Lordship may kindly note this also. Producing, manufacturing fake prize-winning lottery tickets, which, after telling the same from the results published by Nagaland State Lotteries. These persons then release such fake printing prize-winning lottery tickets into the market and encase them with the retailers, and ultimately the retailers of lottery tickets get duped from their activities. Furthermore, state of Nagaland, West Bengal leaves rupees 5 lakhs per weekly draw drawn duly and rupees 10 lakhs per bumper draw for sale of other state lotteries. Knowing well of these facts, the persons involved in the printing and circulating of the fake lottery tickets are evading such draw charges to the state of West Bengal. Further, from the date of inception of GST in India, the sale of lottery tickets 28 GST, and it can be evident from the act of the accused persons that they have also defrauded the respective state and central government for a huge sum of money. Concerning non-payment of GST, you also have defrauded the government from other related taxes and or draw charges applicable. To be more precise, the accused persons are conducting the business of printing and selling fake lottery tickets in the state of West Bengal without paying any statutory taxes. Further, it is learned from the different sources that the above persons are further involved in conducting, organizing illegal online lotteries by various dubious names and most illegally run the same in the state of West Bengal, being fully aware of the fact that by dint of Kolkata Gazette Extraordinary Notification number so-and-so dated 21st May 2013, the state of West Bengal was banned the sale of marketing of online lottery tickets in the state of West Bengal. In the light of aforementioned circumstance, we request your good office to kindly take necessary action against the perpetrators for offences of dealing and selling of illegal paper lotteries in various parts of West Bengal, cheating public by illegally conducting online lottery draws using their personal computer machines not connected to the central server, misuse of Nagaland state logo and theft of important official documents pertaining to Nagaland and state lotteries which were furnished to Atul Bokria in the RTI replies. An instantaneous action will protect the innocent common citizens from fraud and also save the numerous honest people who are associated with the legal paper lottery business and are doing business sincerely to earn a livelihood to support their families. It is therefore requested to take stern action against the offenders by initiating appropriate legal proceeding, including the registration of the first information report, and prosecute them for the commission of various offences required under the law against the culprits, so that such instances should not happen in near future. The same will not only safeguard the image and reputation of the Nagaland state lotteries, but will also protect the innocent populace from these frauds and will safeguard the revenue of the state of West Bengal and central government. So, Lordship, the first perusal of the first information report makes it clear that they were printing fake lottery tickets, they were selling the fraud lottery tickets. That is how revenue was lost, Your Lordship. My first line of argument is that there was the revenue, a huge revenue loss has occurred to the state of Nagaland. They used fake logo, they printed fake lottery tickets. So that is why, and Your Lordship may kindly peruse, who is the informant? The informant in this case is Jyotiba Dahu, is the director, Nagaland State Lotteries, Kohima. Every lottery ticket in my respectful submission, Your Lordship, that has been issued, there is a signature of the director, Nagaland State Lotteries. Every lottery ticket is issued. And that is why, Your Lordship, this particular first information report was filed.
So just show the court how this is different from the FIR which is lodged in Kolkata, in West Bengal.
Because of this,
Isn't it the same?
No, Your Lordship. Because they are using this, these printing tickets, the logo is being used, Your Lordship. The logo of Nagaland State Lottery is used.
No, there also, in West Bengal also, they have detected the use of the logo,
Yes,
Nagaland.
Your Lordship. They have used. But because the revenue is lost, Your Lordship, the revenue of Nagaland state government has been used. They are not getting the revenue, Your Lordship. That is the reason.
Yes, then.
Your Lordship, on the last occasion, my learned friend was referring to two judgments, Your Lordship. That is, one is T.T. Anthony, and the other one is Arnab Goswami's case, Your Lordship. In that connection, I would like to refer to a judgment of the Honorable Supreme Court.
Yes.
AR 2025, Supreme Court 1096. Para 7, 8,
Para 7,
7, 8, 9, and 11. Also.
Yes.
We find that the judgment of this court titled T.T. Anthony records the position that the second FIR is not maintainable. The relevant extract is as under a just balance between the fundamental rights of the citizens under Article 19 and 21 of the Constitution and the expansive power of the police to investigate a cognizable offence has to start by the court. There cannot be any controversy that subsection 8 of section 173 CRPC empowers the police to make further investigation, obtain further evidence, both oral and documentary, and forward a further report or reports to the magistrate. In Narang case, it was, however, observed that it would be appropriate to conduct further investigation with the permission of the court. However, the sweeping power of investigation does not warrant subjecting the citizen each time to fresh investigation by the police in respect of same incident, giving rise to one or more cognizable offence, consequent upon filing of successive FIRs, whether before or after filing the final report under section 172 CRPC. It could clearly be beyond the purview of section 154 and 126 CRPC, nay a case of abuse of the statutory power of investigation in a given case. In our view, a case of fresh investigation based on the second successive FIRs, not being a counter case filed in connection with the same or connected cognizable offence alleged to have been committed in the course of the same transaction and in respect of which pursuant to the first FIR, either investigation is underway or final report under section 172 has been forwarded to the magistrate may be a fit case for exercise of power under section 482 CRPC or under article 226 of the Constitution. This rule, however, over the years, those true judicial pronouncement has lent some flexibility in reference may be made to. In Anju Chaudhary versus State of UP, this court dealt with the concept of the second FIR at length. We may reproduce with profit certain observations as under on a plain construction of the language and scheme of section 154, 156, and 190 of the code. It cannot be construed or suggested that there can be more than one FIR about an occurrence. However, the opening words of section 154 suggests that every information relating to commission of a cognizable offence shall be reduced into writing by the officer in charge of the police station. This implies that there was to be a first information report about an incident which constitutes a cognizable offence. The purpose of registering an FIR is set to machinery of criminal investigation into motion, which culminates into filing of a police report in terms of section 172 of the code. It will thus be appropriate to follow the settled principle that there cannot be two FIRs registered for the same offence. However, where the incident is separate, offences are similar or different, or even where the subsequent crime is of such magnitude that it does fall within the ambit and scope of the FIR recorded first, then a second FIR could be registered. The most important aspect is to examine the inbuilt safeguards provided by the legislature in a very real language of section 154 of the code. These safeguards can be safely deduced from the principle akin to double jeopardy rule of fair investigation and further to prevent abuse of power by the investigating authority or the police. Therefore, second FIR for the same incident cannot be registered. Of course, the investigating agency has to determine determinative right. It is only a right to investigate in accordance with the provisions of the code. The filing of report upon completion of investigation, either for cancellation or alleging commission of an offence, is a matter which once filed before the court of competent jurisdiction attains a kind of finality as far as police is concerned, may be in a given case, subject to the right to further investigation, but whenever the investigation has been completed and a person is found to be prima facie guilty of committing an offence or otherwise, re-examination by the investigating agency on its own should not be permitted merely by registering another FIR with regard to the same offence. If such protection is not given to the suspect, then possibility of abuse of investigating power by the police cannot be ruled out. It is with this intention in mind that such interpretation should be given to section 154 of the code, as would not only further object to law, but even that of just and fair investigation. More so in the backdrop of the settled canons of criminal jurisprudence, re-investigation or de novo investigation is beyond the competence of not only the investigating agency, but even that of the learned magistrate. The courts have taken this view primarily for the reason that it would be open to the scheme of the code and more particularly section 167.2 of the code. In Kari Chaudhary vs. Sita Devi, this court held learned counsel adopted an alternative contention that once the proceeding initiated under FIR number so and so ended in final report, the police had no authority to register a second FIR number it as FIR number so and so. Of course, the legal position is that there cannot be two FIRs against the same accused in respect of the same case. But when there are rival versions in respect of the same episode, they would normally take the shape of two different FIRs, and investigation can be carried on under both of them by the same investigating agency. Even that apart, the report submitted by the court styling into the FIR number so and so need to be considered as an information submitted to the court regarding the new discovery made by the police during investigation that persons not named in FIR number 135 were real culprits. To quash the said proceedings merely on the ground that final report has been laid in FIR number so and so is to list to too technical. The ultimate objective of every investigation is to find out whether the offence alleged has been committed, and if so, who have committed it. The position regarding the second FIR has been clarified by a three-bench judge of this court in Upkar Singh vs. Ved Prakash. The relevant discussion made in the judgment is extracted herein below for ready reference. From the above, it is clear that even in regard to the complaint arising out of complaint on further investigation, if it has found that there was a larger conspiracy than the one referred to in the previous complaint, then a further investigation under the court culminating in another complaint is permissible. So may I pause for a moment? Here it makes it very clear that if there is a larger conspiracy, now this is a case here, let's see, where there is an interstate conspiracy going on. They have conspired here, Lordship. And state of Nagaland is suffering. They are using false logo, they are counterfeiting the property marks, Your Lordship. They are giving falsification, they are using high value false lottery tickets, Your Lordship. Now, may I continue, Your Lordship?
Yes.
A perusal of the judgment of this court in Ramlal Narang vs. State also shows that even in cases where a prior complaint is already registered, a counter complaint is permissible, but it goes further and holds that even in cases where a first complaint is registered and investigation initiated, it is possible to file a further complaint by the same complainant based on the material gathered during the course of investigation. Of course, this larger proposition of law laid down in Ramlal Narang is not necessary to be relied on by us in the present case. Suffice to say that this discussion Ramlal Narang is in the same line as ground in judgment in Kari Chaudhary and State of Bihar so and so. Be that, paragraph 23, Your Lordship, be that as it may, in the law laid down by this court in T.T. Antony's case, is to be accepted as holding that a second complaint regarding the same incident filed as a counter complaint is prohibited under the code, then in our opinion, such contention will lead to serious consequences. This will be clear from the hypothetical example given herein below, that is, if in regard to a crime committed by a real accused, he takes the first opportunity to lodge a false complaint, and the same is registered by the jurisdictional police, then the aggrieved victim of such crime will be precluded from lodging a complaint giving his version of the incident in question. Consequently, he will be deprived of his legitimate right to bring the real accused to book. This cannot be purport of the court. We have already noticed that in T.T. Antony's case, this court did not consider legal right of an aggrieved person to file counterclaim of the contrary. From the observations found in the said judgment, it is clear that filing a counter complaint is permissible. Then I am skipping that part, Your Lordship. I am coming to 9, paragraph 9. From the above conspirators of judgments, inter alia, the following principles emerge regarding the permissibility of the registration of a second FIR. When the second FIR is counter complaint or represents a rival version of a set of facts in reference to which an earlier FIR already states registered, when the ambit of the two FIR is different, even though they may arise from the same sets of circumstances. This is the point where I want to harp on, Your Lordship. When the ambit of the two FIRs, here the ambit of the two FIRs is different, even though they may arise from the same sets of circumstances. They have committed a crime in West Bengal, Your Lordship, but state of Nagaland is getting affected. They have used the logo, the state of Nagaland's logo, Your Lordship. They have falsified many things, Your Lordship. They committed forgery. Then, when the investigation and or other avenues reveal the earlier FIR or set of fact to be part of larger conspiracy. Next part, Your Lordship. When the investigation and or other avenues reveal that the earlier FIR or set of facts to be part of a larger conspiracy. So this is a larger conspiracy, Your Lordship. When investigation and or persons related to the incident bring to the light heated to unknown facts or circumstances where the incident is separate, offences are similar or different. As regards Supra, the High Court found that two FIRs were indeed in regard to the same offence and therefore not maintainable. However, in our view, the escape of the two FIRs is already referred to in Para 3, Supra are distinct. The FIR prior to point of time refers to a particular incident and the action taken therein is limited. So this is the facts of the case. Now here in my respectful submission, Lordship, although there are different FIRs, that are been filed in state of West Bengal. But this is a different FIR. They have committed a crime. The accused persons, Your Lordship. I'm also relying on a three-bench judgment, Your Lordship, AR 2004, Supreme Court 4320. I'm relying on paragraph 50. I've already read the contents, Your Lordship, in the other case. This is I'm only referring to it because this is the three-bench judgment, Upkar Singh versus Ved Prakash.
Yes, it was referred to.
Yes, it was referred to in the 2025 judgment, Your Lordship. And that is why I'm placing it. I'm not reading it again, Your Lordship. Then I'm relying on a judgment, AR 2025. AR 2025-4592. The facts in this case, Your Lordship, was that the petitioners prayed for clubbing the FIRs together, that they filed in different states with respect to a crime. Now, the Supreme Court, what the Supreme Court said, Your Lordship, may I read? I'm reading from paragraph 8 to 12. This is Odela Satyam versus State of Telangana.
Okay. Late.
May I read it also?
Yes.
It was noticed that therein, the offence was one of an alleged objectionable statement leading to hurting of religious sentiments telecast in a television show, which stands distinct from the instant case wherein FIRs were registered on the complaints of the investors or depositors who were alleged to have been duped by the firm, diverting the funds leading to loss of their
Life savings.
life savings. We cannot forget that after investigation, if a charge sheet is filed, the trial will have to be proceeded with producing witnesses being the investors or depositors from various locations, in which event the clubbing of affairs from the state should not be practical. In this context, we also refer to the decision in Amanat so-and-so, paragraph 9. I'm skipping paragraph 9. This court followed the principle laid down in Amish Devgan and invoked the power conferred under Article 143 of the Constitution of India, but only permitted consolidation of the FIR placed in the state of Madhya Pradesh. The prayer for transfer of cases pending in the states of Karnataka and Jharkhand were specifically rejected. We have also noticed Section 242 of the Bharatiya Nagarik Suraksha Sanhita 2023, which enables offences of same kind within the year to be charged together. Section 242 provides that where a person is caused of more offences than one of the same kind, committed within the space of 12 months from the first of the last such offence, whether in respect of the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 5. In the present case, the FIRs filed are the following. So these are the FIRs, Your Lordship, in different states. 12 is very important, Your Lordship. As we noticed, in Telangana there are 4 crimes registered, 3 by the economic offences being Cyberabad and 1 in Madhupur, Cyberabad. Hence the FIR registered in Madhupur, Cyberabad will stand transferred to economic offences being Cyberabad. In the state of Maharashtra, there are 2 FIRs registered, one in Ambazari, Nagpur city, with the other in Waghal state, Thane state. The FIR 2010 of 2025 registered in the Waghal state, Thane city will be transferred to Ambazari, Nagpur city. The clubbing of the single FIRs filed in the state of Karnataka, West Bengal, Delhi, Andhra Pradesh, Rajasthan states rejected. So why I am placing this judgment in Your Lordship is that the accused petitioners, they could have prayed for clubbing of the FIR if they are aggrieved by the fact that it is raising from the same set of allegations. The Supreme Court is very clear, Your Lordship. The clubbing is not allowed. They have not allowed declubbing of the FIRs, Your Lordship. And in this case, Your Lordship, this is a completely separate set of crime that has been committed, Your Lordship. The accused petitioners have committed a crime to the state of Nagaland per se, Your Lordship, in my respectful submission. It's a cross-state scenario and the offence affects the revenue, Your Lordship. It impacts the economy of the state of Nagaland. T.T. Anthony and, Your Lordship, T.T. Anthony case and Arnab Goswami's case, they were of the same incident, Your Lordship. The same incident, there were different affairs, that is why the Supreme Court said that.
Acha, the Bidhannagar police station case, who was the complainant?
Noodle officer of the State Lottery Department.
Kolkata.
Kolkata came, yes,
Kolkata,
but the Nagaland State Lotteries.
That was closed. But
That is not closed, my lord. We have not been charged.
you were not charged. Then the other one,
Harry Street,
That-
the number one.
that number one.
Number one,
filed
charge sheet
it?
has not been filed.
No,
That
who filed it?
Another person, one Patnaik,
No, who was he? Who was he?
he's not related to the state. He's not an employee of the state.
No, what I mean is he was also
He says he's a
person
purchaser.
who was duped.
Yes,
Who
he
was a
says, yes,
purchaser?
yes.
Okay. Yes. Yes, please continue.
Then I'm referring to another judgment, Your Lordship, with respect to the Melaf idea as to whether the court will interfere. This year 1996, Supreme Court 722. I'm relying on paragraph number 22, 23, and 24.
Yes.
May I read, Your Lordship? In fact, I'm not stating the facts, Your Lordship. In fact, the question of malafide in a case like the present is not at all relevant. If the complaint which made is correct and an offence has been committed which will have to be established in the court of law, it is of no consequence that the complainant was a person who was immunicable or that he was guilty of malafide. If the ingredients will establish the commission of the offence of misconduct exists, the prosecution cannot fail merely because there was an animus of the complaint or the prosecution against the accused. Allegations of malafide may be relevant while judging the correctness of the allegations or while examining the evidence, but the mere fact that the complainant is guilty of malafide would be no ground for quashing the prosecution. In the instant case, specific affirmations of facts have been made whereby it was alleged that the respondent has disappropriated large assets. Malafide intention on the appellant in launching prosecution against the respondent with a view to punish him cannot be a reason for preventing the court of competent jurisdiction from examining the evidence which may be laid before it, for coming to the conclusion whether an offence has been committed or not. Allegations of malafide were also made in so-and-so case against the informer. It was held by this court that when an information is lost at the police station and an offence is registered, then the malafide of the informant wouldn't be of secondary importance. It is a material collected during an investigation and evidence laid in court which decides the fate of accused persons. The allegation of malafide against the informant are of no consequences cannot by itself be a basis for quashing the prosecution. The court has consistently taken a view that the court should not, except in extraordinary circumstances, exercise its jurisdiction under section 482 CRPC so as to quash the prosecution proceeding after they have been launched. In KPS Gill's case, so and so it was entirely observed that we also give a note of caution to the effect that the power of quashing in criminal proceedings should be exercised very sparingly with circumspection and that too in the rarest of the rare cases, that the court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the first information report or the complaint, and that the extraordinary or inherent power do not confer an arbitrary jurisdiction on the court to act according to its rule or caprice. Now, why I am placing this judgment, Your Lordship, is that an endeavor has been made to establish the fact that this particular person who is the informant in this case, there is a mala fide intention on his part in filing the FIR in the state of Nagaland, Your Lordship. There is no mala fide intention, Your Lordship. This is a cross-border act, and the state of Nagaland is affected. That is why this particular director, he has filed the FIR, Your Lordship. There is no mala fide intention on our part. I'm also placing the Bhajan Lal case, Your Lordship. I'm just reading one paragraph from Bhajan Lal, like the Lordship is aware.
Scope of 482.
Yes, Your Lordship. The scope of 482, as Your Lordship is aware, but I'm just relying on two paragraphs. Your Lordship may kindly allow me to read. Paragraph 108 and 109.
Yes.
In the backdrop of the marriage, Your Lordship.
Yes, yes.
In the backdrop of the interpretation of various relevant provisions of the Code under Chapter 14 and of the principles of law enumerated by this Court in a series of decisions relating to the exercise of extraordinary power under Article 226 or the inherent powers under Article 4, Section 482 of the Code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice. Through it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines of rigid formula, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. Where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused. In my respectful submission, Your Lordship, the FIR is very crystal clear, Your Lordship, that the accused person has committed a crime. Where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offence, justifying an investigation by police officer under Section 156(1) of the Code, except under the order of the magistrate within the purview of Section 125(2) of the Code. If I may pause for a moment, Your Lordship. The sections in this case, Your Lordship, at first the case was registered under Section 120B, 417, 464, 465, 469 IPC, and later on, Your Lordship, Section 34, 420, 500, 467, 468 was added and read with Section 7(3) of the Lotteries Regulation Act 1988. So, perusal of the first information report makes it evidently clear, Your Lordship, that these sections are getting interacted. So these are cognizable offences, Your Lordship, and the police has very rightfully conducted an investigation into the case. I will come to that part later on with respect to the investigation part, Your Lordship. Where the uncontroverted allegations made in the FIR complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused. This is not the case, Your Lordship. Where the allegations in the FIR do not constitute a cognizable offence but constitute only a non-cognizable offence, no investigation is permitted by the police officer without an order of magistrate as contained under Section 155(2) of the Code. Now, in this case, Your Lordship, the case was also registered under Section charge sheeted, Your Lordship, and it was charge sheeted under Section 499. That is a non-cognizable offence. I'll come to that later on, Your Lordship. Why, whether the cognizable offence and non-cognizable offence can be investigated together. If there is a non-cognizable offence also. A charge sheet has been filed, Your Lordship. I'll come to that later, but may I read it again? Where the allegations in the FIR do not constitute a cognizable offence but constitute only a non-cognizable offence, no investigation is permitted by the police officer without an order of magistrate as contemplated under section 155(2) of the code. Where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. Where there is an express legal bar engrafted in any of the provisions of the code or the concerned act under which a criminal proceeding is instituted to the institution and continuance of the proceeding, and or where there is a specific provision in the code or the concerned act providing efficacious redress for the grievance of the aggrieved party, where the criminal proceeding is manifestly attended with mala fide, and or where the proceeding is maliciously instituted with the ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. This is not a case where there is the director has a personal grudge against the accused person. That is not their case. We also give a note of caution to the effect that the power of quashing a criminal proceeding should be exercised very sparingly and with circumspection, and that too in the rarest of the rare case, that the court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR or the complaint, and the extraordinary or inherent powers do not confine arbitrary jurisdiction of the court to act according to its whim or caprice. So Bhajan Lal makes it absolutely clear, Your Lordship.
Bhajan is always there. Just the other day also I have quoted this 7 criteria from Bhajan. Yeah, next.
This is the P. Chidambaram case, Your Lordship. This is also about the 482 and whether it falls under the category of rarest of the rare case, Your Lordship. I'm relying on paragraph 60 forwards, Your Lordship. May I read, Your Lordship?
Yes.
The investigation of a cognizable offence and the various stages thereon, including the interrogation of the accused, is exclusively reserved for the investigating agency whose powers are unfettered so long as the investigating officers exercise his investigating powers well within the provisions of the law and the legal bounds. In exercise of its inherent power under section 482 CRPC, the court can interfere and issue appropriate directions only when the court is convinced that the power of investigating officer is exercised mala fide or where there is abuse of power and non-compliance of the provisions of the Code of Criminal Procedure. However, this power of invoking inherent jurisdiction to issue direction and interfering with the investigation is exercised only in rare cases where there is abuse of process or non-compliance of the provisions of Criminal Procedure Code. In King Emperor versus Khwaja Nazir Ahmed, AR 1945, PC 18, it was held as under, it is of utmost importance that the judiciary should not interfere with the police in matters which are within their province and into which the law imposes upon them the duty of inquiry. In India, as has been shown, there is a statutory right on the part of the police to investigate the circumstances of an alleged cognizable crime without requiring any authority from the judicial authorities. And it would be their lordships think be an unfortunate result if it should be held possible to interfere with those statutory rights by an exercise of the inherent jurisdiction of the court. The functions of the judiciary and the police are complementary for not overlapping, and the combination of individual liberty with a due observance of law and order is also to be obtained by leaving each to exercise its own function, always of course subject to the right of the court to intervene in the appropriate case where moved under section 419 of the Criminal Procedure Code. The above decision in Khwaja Nazir Ahmed has been quoted with approved by the Supreme Court in Abhinandan Jha and others versus Dinesh Mishra, AR 1968, Supreme Court 1 and 17, and State of Bihar and another JAC Sandanha and others Observing that the investigation of the offence is a field exclusively reserved for the executive through the police department and the superintendent over which based in the state government, in JSS Andha it was held as under. There is a clear-cut and well-demarcated sphere of activity in the field of crime detection and crime punishment. Investigation of an offence is the field exclusively reserved for the executive through the police department and the superintendents over which based in the state government. The executive, which is charged with the duty to keep vigilance over law and order situations, obliged to prevent crime, and if an offence is alleged to have been committed, it is bound their duty to investigate the offence and bring the offender to book. Once it is investigates and finds an offence having been committed, it is the duty to collect evidence for the purpose of proving the offence. Once it is completed and the investigating officer submits report to the court requesting the court to take cognizance of the offence under section 190 of the code, its duty comes to an end. On a cognizance of the offence being taken by the court, the police functions of investigation comes to an end, subject to the provisions contained in section 173(8). There commences the adjudicatory function of the judiciary to determine whether an offence has been committed, and if so, whether by the person or person charged with the crime by the police in his report to the court, and to award adequate punishment accordingly to the law for the offence proved to the satisfaction of the court. There is thus a well-defined and well-demarcated function in the field of crime detection and its subsequent adjudication between the police and the magistrate. This has been recognized way back in King Emperor versus Khwaja Nazir Ahmed, AR 1945. The same view has been reiterated in Dukhi Syam Venupadhyay, Assistant Director so-and-so. I'm skipping that part. 63. Investigation into crime is a prerogative of the police, and excepting in rare cases, the judiciary should keep out all the areas of investigation. State of Bihar and another versus P.P. Sharma, IS and another 1992, 1 SCC 222. It was held that the investigating officer is an arm of the law and plays a pivotal role in the dispensation of criminal justice and maintenance of law and order. Enough power is therefore given to the police officer in the area of investigating process and granting them the court latitude to exercise his discretionary power to make a successful investigation. In Dukhisaran Benupani, Assistant Director Enforcement Directorate, it is not the East Court held that it is not the function of the court to monitor investigation process so long as such investigation does not transgress any provisions of law. It must be left to the investigating agency to decide the venue, the timing, and the question and the manner of putting such question to person involved in such offences. A blanket order fully insulating a person from an arrest would make his interrogation a mere ritual. As held by the Supreme Court in the Catena of Judgment, that there is a well-defined and demarcated function in the field of investigation and its subsequent adjudication. It is not the function of the court to monitor the investigation process so long as the investigation does not violate any provisions of law. It must be left to the discretion of the investigating agency to decide the course of investigation. If the court is to interfere in each and every stage of investigation and the interrogation of the accused, it would affect the normal course of investigation. It must be left to the investigating agency to proceed in its own manner in interrogation of the accused, nature of questions put to him, and the manner of interrogation of the accused. It is one thing to say that if the power of investigation is exercised by an investigating officer Melafaidi on non-compliance of the provisions of the Criminal Procedure Code in the conduct of investigation, it is open to the court to quash the proceeding. I'd like to pause for a moment, Your Lordship. In the present case, they are not alleging, neither alleging Melafaidi, nor there is any violation of the Code of Criminal Procedure. It is a different matter that the High Court, in exercise of its inherent power under Section 482 CRPC, the court can always issue appropriate directions at the instance of an aggrieved person if the High Court is convinced that the power of investigation has been exercised by the investigating officer Melafaidi and not in accordance with the provisions of the Criminal Procedure Code. However, as pointed out earlier, the code is to be exercised in rare cases where there is a clear abuse of power and non-compliance of the provisions falling under Sector 12 of the Code of Criminal Procedure, requiring the interference of the High Court in the initial stage of investigation where the court is considering the question of grant of regular bail or pre-arrest bail. It is not for the court to enter into a demarcative function. Anyways, Your Lordship, this is with respect to the other part. So, Chidambaram case made it absolutely clear, Your Lordship, with respect to the investigating part and the function of the investigating officer, Your Lordship. And in the present case, the investigating officer conducted a proper investigation. They are not questioning the investigating process, Your Lordship. And more importantly, after completion of investigation, a charge sheet has been filed. A charge sheet has been filed, Your Lordship, on 25/8/2025.
28?
It was filed on 25/8/2025. So, prima facie, it seems, Your Lordship, after the investigation, After completion of investigation, there are certain allegations that we found to be true, and that is why the charges has been filed. Now, I'm also relying on another judgment, Your Lordship. Air 2021 Supreme Court 1918. This is Niharika Infrastructure, Your Lordship is aware. Niharika Infrastructure was the state of Maharashtra. I'm just reading one paragraph, Your Lordship.
This para.
Paragraph 23. I'm not reading the other paragraph, Your Lordship, just the. Lordship, paragraph 23. Internal please.
Yes.
In view of the above and for the reasons stated above, our final conclusion on the principal core issue whether the High Court would be justified in passing an interim order of stay of investigation and or no coercive steps to be adopted during the pendency of the Quashing petition under Section 482 CRPC and or under Article 2 of the Constitution of India, and what circumstances whether the High Court would be justified in passing the order of not to arrest the accused or no coercive steps to be adopted during the investigation until the final report such is filed under Section 173 CRPC, while disposing of, not entertaining, not quashing the criminal proceeding complaints FIR in exercise of powers under Section 482 CRPC and under Article 226 of the Constitution of India. Our final conclusions are as under. Police has the statutory due right and duty under the relevant provisions of the Code of Criminal Procedure contained in Chapter 14 of the Code to investigate any cognizable offence. Courts would not thwart any investigation into the cognizable offences. It is only in cases where no cognizable offence or offence of any kind is disclosed in the first information report that the court will not permit an investigation to go on. The power of quashing should be exercised sparingly with circumspection, as it has been observed in the rarest of rare cases, not to be confused with the foundation of the context of death penalty. So that is also clarified here, Your Lordship. While examining an FIR complaint quashing in which is sought, the court cannot embark into an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR complaint. Criminal proceedings ought not to be scuttled at the initial stage. Quashing of a complaint FIR should be an exception rather than an ordinary rule. Ordinarily, the courts are barred from usurping the jurisdiction of the police, since the two organs of the state operate in two specific spheres of activities and one ought not to be tread over the other sphere. The functions of the judiciary and the police are complementary, not overlapping, save in exceptional cases where no interference will result in miscarriage of justice. The court and the judicial process should not interfere at the stage of investigation of offences. Extraordinary and inherent powers of the court do not confer an arbitrary jurisdiction on the court to act accordingly to its whims and caprice. The first information report, Your Lordship, may kindly note, the first information report is not an encyclopedia which must disclose all facts and details relating to the offence reported. Therefore, when the investigation by the police is in progress, the court should not go into merits of the allegations in the FIR. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy facts that the complaint and FIR does not deserve to be investigated or that it amounts to abuse of process of law. After investigation, if the investigation officer finds that there is no substance in the application made by the complaint, the investigating officer may file an appropriate report summary before the learned magistrate, which may be considered by the learned magistrate in accordance with the police procedure. The power of the Section 482 CRPC is very wide, but conferment of wide power require the court to be more cautious. It facts an onerous and more diligent duty on the court. However, at the same time, the court, if it thinks fit, regard being held to the parameters of quashing and the self-restraint imposed by law, more particularly the parameters laid down by this court in case of R.P. Kapoor and Bhajan Lal, has the jurisdiction to quash the FIR complaint. When a prayer for quashing the FIR is made by the alleged accused, and the court, when it exercises the power under Section 482, CRPC only has to consider whether the allegations in the FIR disclose commission of cognizable offence or not. Now here in this case, Your Lordship, the charge sheet is already filed. The investigation is complete. So even assuming, Your Lordship, the FIR did not disclose anything. Now it is very clear. The particular accused persons, they had committed a cognizable offence. and they need to face the trial. Why is they are shying away from facing the trial? The court is not required to consider the merits, whether or not the merits of the allegations make out a cognizable offence, and the court has to permit the investigating ANC police to investigate the allegations in the FIR.
No, counsel, these are the general principles of quashing. I understand.
Yes.
But their case is that, their specific case is that there is a second FIR on the same set of facts.
No,
That's the only case.
That is what I'm saying. That is what I'm saying. That is my respectful submission, is that these are not same facts, Your Lordship. They're different facts, because once the state loses,
So now the court has to see,
the logo is
Yes.
to make out the difference. That's all. Try to make out the difference. No.
Simple as that.
Yes, anything else?
Yes, ma'am.
You have not completed, no?
No, Your Lordship.
Okay. Yes. Try to wrap it up. We are now at 4:30. Yes.
It will take some time, Your Lordship.
It will
I've
take
got
time.
other- Yes, Your Lordship.
Should we continue tomorrow then?
It will be difficult for me, Your Lordship. May I pay for a day and the next day?
No. Now, how long will you take?
Your Lordship, I'm praying for a day because I was here to finish off the case.
10 minutes? 10, 15
It will
minutes?
take more time, Your Lordship. It will take
More
some
than
time.
that?
Yes, Your Lordship. I'm still have to start my argument. I've not started my argument. I'm just in the judgment.
Okay. Then we'll fix another date.
Yes, Your Lordship.
Next week?
Monday?
Next week it will be a bit difficult, Your Lordship. May I pray for a...
And not on a Wednesday. See, today
Yes,
also
yes.
we could not complete the cases.
Can have it on Monday or Tuesday, next Monday, Tuesday.
16, 17, any day.
Yes, 16, 17. any day.
May I pray, Your Lordship, may kindly fix it on 24th of February, if Your Lordship may kindly
24th.
accommodate.
My lady, 24 also difficult for me. We have already a matter fixed on that.
23rd?
23rd.
Yes, 23rd.
23rd?
23rd.
Langadini.
23rd.
My lady. My lady, I have matter fixed already. So the next week, any day, the next week.
Yeah, next week it will be
Next week,
difficult.
any day will be fine.
Next week he has difficulties.
I have difficulties, so I'm sorry.
Cases are fixed, my lord, my lady. Now,
Or a Thursday, Your Lordship, on
Then
26th.
26th?
Yes, I'm ready with that, 26th.
trial matter fixed again.
The whole week.
The whole week, that week.
Then 2nd March.
Yes, Your Lordship. No issue, I'll be there.
Again, trial and Mokchung.
No. You have to give preference to the High Court.
No, my lady, I'm saying,
Second.
can we just have it any day next week?
Next week I have problems.
He has problem and he's outstation lawyer, so
Huh?
we have to give some concession.
23rd, no Kijilir.
2nd of March, Your Lordship.
You cannot be having cases every day from 23rd to 27th.
No, yeah, no.
23rd.
My lady, what has happened is because of my condition, all the matters have been jumbled up. But 23rd or 22nd,
22nd is a Sunday.
23rd, then.
23rd. 23rd, Mr. Deary?
Yes, Your Lordship. I don't know the question.
Okay. The third Learned Counsel, Mr.
Now?
P. Deary for the, Mr. Imti Longcham for the petitioner and Mr. P. Deary for the respondent. Matter is part third, list as part third matter on 23/2/2026, at the top of the list, okay? Top of the list, number 1. Yeah. Let's try to finish it on that day.